We are the elected member of the
Page 14 or 4040?
40.
Okay. Hmm. Yes, you are the elected member.
May I go to?
Yes. Are you ready?
No, my lord. Actually, service report upon the respondent number 1 to 8 is not yet completed. I'm appearing on behalf of the respondent number 9.
This one number 9.
Yes, my lord. And the petitioners council have not yet served me extra copies.
Oh, okay. One to 8 are yet to yet to get notices.
Yes, my lord.
We have taken step, Lordship, but being this now the condition of road is very deteriorated. It has taken long time. In fact, Lordship, today we want to pray that this interim be kindly granted. Otherwise, the 3 months suspension is almost exhausted. In other case also that while taking step, the 3 months suspension is exhausted and it was disposed on infractuous, Lordship. So if we don't, if interim relief is not given to us, the very purposes of this case will be
My lord, let me
Frustrated.
obtain instructions first with regards to the interim.
Okay, so when was the last order passed?
2910, 24.
29, 10, 11, 12. So how many days you want to get instructions?
My lord, let the petitioner serve me a copy of the writ petition, then I will serve it to the concerned department.
How long will it take?
My lord, 2 weeks.
So he's got only 2 months with him.
Yes, my lord.
29, 10. So it will be 29, 11.
the Secretary, Lordship Secretary to the Minority and Parliamentary Affairs Department is here only. If we furnish copy
So
today
we
itself, they
will
can.
give you 1 week's time? Or
Yes, my lord.
1 week's time? We'll fix a date.
Yes.
And what about serving the notices from 1 to 9? Okay, before
have-
serving notices, you want to get the order, interim order.
Yes.
All right. Learned Counsel, Mr. Your name?
A.K. Rokum.
A.K. Rokum is present on behalf of the petitioner. Learned Counsel, Miss,
Caroline K. Lungoypui,
is present. Learned Additional AG,
government advocate, my lord.
Learned Government Advocate, Miss so-and-so is present on behalf of the respondent number 9. Notice service report of notice on respondent number 1 to 8 is awaited. Meanwhile, the learned government advocate has submitted for time to obtain instructions from the respective department. List matter on 18 November.
Yes.
Item number 2.
My lord, item number 2 is also similar matter.
Learned Counsel Mr. A.K. Rokum is present on behalf of the petitioner. How many responses do we have here? Learned Government Advocate Ms. So-and-so is present on behalf of the state of Mizoram. Respondent number 9.
Respondent number 6, my lord.
Respondent number 1, not respondent number 1.
Yeah. Now, respondent number 1.
Respondent number 1, okay.
Two and 3 we have already served and Dastri and we have filed affidavit also.
They file affidavit, yes. Affidavit of Dusty Service filed. Any order has been passed? Operator respondent are directed to place before this court there. Stand by filing the affidavit. Whether respondent have power to suspend executive body. or respondent number 2 and 3 were directed to submit a report.
No,
Wait,
we have already served two entry by Dusty.
Dusty. No, they have already received this last order reflects last order 29/10/2024 reflects.
Yes, Lordship, para 11 of that accordingly the court fixed this matter 8/11/2024 on which that the interim orders may be by the petitioner be duly considered. That
And
is
then
para-
respondent number 2 and 3, I think, is the department. They are directed to place before this court their standby, filing the affidavit. So it is, I think, notice has been served to respondent number 2 and 3.
Yeah.
So 1, 2, and 3. Only we have only 3 respondents.
The other two, these private respondents are there. Four and five are they're the
Private respondents. Service report on respondent number 4 and 5 is awaited.
yes,
Huh?
yes.
You note it down. Service report on respondent number 4 and 5 is awaited. And then learned government advocate has submitted for time to obtain instructions
Yes,
from the
madam.
respective department.
Yes, madam.
List the matter on 18 November.
Item number 3.
My lord, I'm appearing on behalf of respondent number 5, and we have received instruction from the NBCC. We will able to file the additional affidavit within a week. Therefore, I pray an adjournment.
Yes. Learned counsel Mr. A.R. Malhotra is present on behalf of the petitioner. Learned government
I'm appearing on behalf of respondent number 4,
government advocate.
Union of India Central Government.
Learned counsel Miss So and so is present on behalf of the respondent number 4. Only respondent number 4. Learned counsel Miss
Lerling Zwali,
is present for the respondent on behalf of the respondent number 5
yes,
and has submitted for time to file an affidavit,
yes, my lord.
additional affidavit,
Yes.
to file an additional affidavit. List the matter after 1 week, 2 week?
1 week.
List the matter after 1 week.
Thank you, my lord.
Item number 4.
Lordship, we have taken newly implemented upon respondent number 10. So we have awaited service report.
Newly implemented, respondent number 10.
Yes. Await service report now.
Service report on respondent number 10 is awaited. Learned counsel for the petitioner, Miss, your name,
Dinari.
is present on behalf of the, is present on behalf, just check out on behalf. Learned counsel, Miss,
Hinmoy, on behalf of Mr. Bilaramenga, for respondent number 5.
please note it down, is present on behalf of, is present for respondent number
Lordship,
5.
I am for respondent number 2 and 7.
Learned counsel, Miss So and so is present on behalf of respondent number 7. Service report on respondent number 10 is awaited.
Awaited.
List the matter after how many weeks? 2 weeks, 3 weeks?
3 weeks.
3 weeks.
Item number 5.
May it please your lordship, in this contempt matter, the
Secretary to the Government of Mizoram, Land Revenue and Settlement Department has sought for a sanction from the Finance Department. A white letter dated 21st February 2024. However, till date, no sanction has been made. So if Your Lordship permits, the Secretary to the Government of Mizoram Finance Department may be implemented as a party.
Don't you, I think you'll have to file an affidavit according to the new Guwahati High Court notification.
As per the last order, the respondents were to file their affidavit.
They have filed an affidavit.
Not yet, my lord.
Ah.
Nevertheless, my lord, they have tried to comply with the order by submitting a letter for sanction from the Finance Department amounting to rupees 13,12,260. That is the amount due to the petitioners. However, the Finance Department has not considered the letter till date, and it's submitted on 21st February 2024. Now it's the end of the year, my lord.
21st of February.
February 2024. It's in the top corner, my lord, in the letter.
Anybody appearing for the respondents? Nobody.
Yes, my lord, I'm appearing for the Secretary Land Revenue and Settlement Department. And as my learned friend have already submitted, we have filed our show cause reply affidavit stating that we have requested a sanction from the Finance Department, which is awaited till now.
They have taken steps.
Pardon, my
They
lord?
have taken steps.
Yes, my lord, they've taken steps, but now they've taken steps in the month of February 2024. Now it's November, my lord.
So I think it would be better to expedite the matter.
Yes. If we can implement the Finance
From
Secretary to the Government of Mizoram.
2024 February, so that response is awaited.
My lord, my learned friend can file a application for implement, my lord, in the meanwhile. If he,
If so required, my lord, I can file.
Huh?
yeah.
If so required, my lord.
Yes, yes. If you want to implement a new party, I think you have to file an affidavit. There has been a notification from the Guwahati High Court. Anything, any implement or even change in the amendment of the cause list also, you'll have to file an affidavit. I think it has become a rule
Yes,
now.
I think I'll have to file an
It has
application.
been included in the rules, I think.
Yes, my lord. An application, not affidavit. Because
Application, yeah.
Application.
Interlocutory application, right, correct.
Yes, my lord.
Correct, not affidavit. Learned Counsel, Mr.
Zoram Sana.
Joram Chanai is present on behalf of the petitioner. The Learned Counsel has submitted that he will file an application for implement of who
Secretary to the Government of Mizoram Finance Department.
as a respondent.
Respondent number.
As respondent, huh? As a respondent.
Yes, my lord.
List the matter after when?
After 2
One-
weeks, my lord. 2 weeks.
2 weeks?
Yes, madam.
For an affidavit? 2 weeks.
For application,
For an
no, just
application.
application, my lord.
List the matter after
2
2
weeks.
weeks.
Obliged, my lord.
All right.
Item number 6.
Your Lordship, in this case, pleadings are complete. It can be fixed for hearing in usual course.
Sorry?
For hearing,
Ah.
usual course.
Okay, okay.
Yeah,
okay.
pleadings are complete.
Pleadings are complete?
Yes.
Let's check. It has been admitted, not admitted.
I'm not sure. I'm not sure whether it's admitted.
I don't think so. It has been admitted. So we'll fix it for admission then.
Yeah.
We'll have to hear the other side for admission.
Yeah.
Lordship, I'm appearing for the state respondents.
Ah.
Yeah, I'm
Matter has
appearing
been
for
admitted
the.
or not admitted?
Yes.
Yes.
Admitted.
That it's not, I believe it's not been admitted yet.
So any problem if I admit it? You have any objection?
And
No,
listed
no,
for
no, Your
hearing.
Lordship.
Not
No
objection.
objection.
So we'll admit
Yes.
and fix it for hearing?
Yes, 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 Your Lordship.
Heard learned counsel Miss
Dinari.
Dinari T. Aizu for the petitioner. Learned counsel and learned government advocate.
Yes.
Government advocate.
Learned government advocate Miss
H. Lalmal Somi.
so and so for the respondents, for all respondents.
Yeah, for all the respondents.
For the respondents. I have considered the submissions of both the sides. After considering the submissions and on and agree, and as after considering the submissions, this petition is admitted. Full stop. List the matter for hearing. We have the LCR and everything. In its usual process.
No need for LCR, Lordship. This is
No
writ
need for
petition.
SCR. This is a writ petition.
Oh, okay, read petition. So,
So it can be listed for hearing in the
in usual process or
Usual course, yes.
usual
course.
course.
you want a date?
No, no, listed for hearing on usual course.
List the matter for hearing in its usual process.
Item number 7.
Lordship, I am appearing on behalf of my senior, Mr. Johnny L. Tau Chong, counsel for the appellant. He is on leave due to some personal difficulties, my lord.
Okay. Learned counsel, Mr.
Johnny L. Tau Chong.
is present on behalf of learned counsel.
Lal mga isang.
Huh?
Lal mga isang.
Who is unable to attend court today. Huh? Correct. It's the other way round. This statutory appeal. Statutory appeal, or it has to be admitted.
My lord, I have no further information about the case.
Oh, it has already been admitted.
Yes,
So this is a conviction.
yes, my lord.
Conviction.
Yes.
We have the LCR and the paper book. Do we have the LCR? Paper book has been prepared, so we have the LCR now. Paper book is ready, and copies have been furnished to both the sides. So we'll list it for hearing.
Yes, my lord.
Matter has already been admitted. Miss Linda is present for the government. Additional PP not present. No, doesn't matter. We can admit it. It's a statutory appeal. We'll have to admit it, and it has already been admitted. List the matter for hearing in its usual process.
Yes, my lord.
Item number 8.
My lord, I am appearing on behalf of the state respondents 1, 2, and 9. And I have already filed my affidavit in opposition on
1, 2, and 9.
Yes,
Lordship, I am for respondent number 4. May I seek another 3 weeks time for filing affidavit?
Okay. And what about the other respondents? 3,
5 to 9.
5, 6, 7, 8.
5 to 8 have not yet filed their affidavit in opposition.
Yet to file.
And
You are present.
yes, my lord.
That earlier order, Learned Counsel so-and-so is present on behalf of Learned Counsel Mr. So-and-so. Learned Counsel Miss
Caroline K. Lungoy
is present
On
on behalf,
behalf
of respondent number
1, 2, and 9.
1, 2, and 9. And Learned Counsel
Baby
Miss
Laldin Zwali for respondent number 4.
is present on behalf of respondent number 4 and has submitted for time to file affidavit in opposition.
Yes, my lord.
List then other 5 and 8. Respondents number 5 and 8 are yet to file.
1,
their-
2, and 9 we have already filed, my lord.
Huh?
1, 2, and 9 we have already filed.
The respondents 1, 2, and 9 have filed their affidavit in opposition, whereas the Respondents 5 and 8, respondent number 5 and 8 are yet to file their affidavit in opposition. You haven't filed?
We have not yet filed.
Then remaining is 3 and 6. Have they appeared? 3 and 6? I'll check.
Three is the Kala.
Hmm?
3 is Kala. And 6 remember.
Haven't appeared? 3. 1, 2 and 9. There's nothing in the order also. Earlier orders also. Three and 8, I think 3 and
3 is the Kala, so Kala is not being represented, and 5 to 8 is
no, they are there.
NHIDC.
5 to 8 is there. We have only 3.
Yes, my lord.
Only 3 has been left out. 3 and 7. Oh no, 5 to 8 is there.
5 to 8 is there.
So only 3. Yes, I think service report has not been returned. Service report has not been returned, I think. Just check. I don't think so. Service report has been returned. To respond number 3. You have the supplementary file. It has been returned, okay. Notices have been served to respondent number, just let me check. Respondent number 3. AD card has been returned after service of notice, but presented today. List the matter after 2 weeks, 1 week, 3 weeks.
0.
3 weeks, my lord. 3 weeks. List the matter after 3 weeks.
For orders, item number 9.
My lord, same goes to item number 9 as well.
My lord, this matter has been restored. Right, order dated 24/10/2024. So, my lord, I will be needing the copy of the petition, my lord.
24, order dated
24/10/2024.
It's the old file, no? Okay, first time they have come after restoration. Long time back it was filed,
Yes, my lord.
2013.
It was disposed.
Oh, disposed for non-prosecution.
Dismissed for non-prosecution.
Dismissed for non-prosecution. Learned Counsel, Mr. is so and so is present on behalf of Learned Counsel, Mr. So and so, for the petitioner, or what is it?
Yes, my lord,
petitioner. For the petitioner, Learned Counsel, Miss
Caroline Kelungaipoy.
is present on behalf. Learned Government Advocate, huh?
Yes, my lord.
Is present on behalf of the respondent,
The sole respondent.
on behalf of the sole respondent. Post up. It is submitted that this civil division petition,
Yes, my lord.
This civil revision petition has been restored to file by order dated 24/10/2024 passed by this court. The petitioner is directed to furnish a copy of the petition to the respondent. Okay? This the matter will then,
After 2 weeks, if possible, madam.
okay. This is the matter after 2 weeks.
Yes. Much obliged.
Item number 10.
My lord, the LCR is received from the trial court. So if paper book may be prepared and the matter may be listed for hearing after the preparation of the paper book.
And what about the notices issued to respondents?
They have submitted the Vakalat Nama, Shraming Thanga.
Oh, yes, yes.
and
Their
others.
names are reflected. Okay. Learned Counsel Mr.
Zoram Sana.
is present on behalf of the appellant. The names of the learned counsel for the respondents are reflected in the cause list. The learned counsel has submitted that paper book may be prepared. Full stop. Has submitted for that paper book may be prepared. Full stop. The paper office to prepare the paper book and list this matter for admission.
Yes, my lord. Obliged, my lord. After completion of the paper book, my lord.
Okay. After preparation of the paper book.
Obliged, my lord.
Item number 11.
My lord, in this matter, I have checked the files and learned that the notice has returned unserved due to insufficient address. So, my lord, kindly allow me to complete the notice through Dusty service.
Learned counsel Mr.
Lalrokung Apautu.
is present on behalf of the applicant stroke appellant. It is submitted that no, it is submitted not required. I'll just check. Office note dated 4/11/24 indicates that notices issued to respondent number 1 and 2 have been returned unserved due to insufficient address. The applicant stroke appellant may issue fresh notice through Dusty service.
Yes, madam.
Routed through Dusty service. List the matter after 4 weeks.
My lord, 2 weeks would be fine.
2 weeks, all right.
Obliged.
For hearing, item number 12.
This is page number. I'll pull it out.
Please, Your Lordship. My Lord, yesterday, basically, I'll just quickly recap. The basic challenge to the judgment in order is
I
not...
remember.
My Lord?
I remember. Recap is not required.
So, basically, that exhibit P13 that we were stuck on here yesterday, that building
Yes,
evaluation.
P13, yes.
So, anyways, Your Lordship, what I was trying to impress on Your Lordship was that as far as the exhibit P13 is concerned, as per section 61 of the Evidence Act, it says that facts may be proved by either way of primary or secondary evidence.
Yes, yes. You have
Section-
given a
Yes, I've given that.
Supreme Court's
Right.
judgment also.
And section 62 says that the original document itself will constitute primary evidence. And it is on record that the original exhibit P13 was brought to the court and the same was compared with the one that was submitted to the court. So that is there. And in any event, Your Lordship, the court witness number 1, that is the engineer, who affixed his signature in the exhibit P13. He was called as a witness, cross-examined by the appellant defendant, and he stated that he was the one who approved the exhibit P13.
CW.
Court witness number 1,
Yes, okay.
which
He
is
has
at, which
proved
can
the, exhibit P13.
yes, which can be found at page 195, paragraph 58. Page 195, paragraph 58. So that was that, Your Lordship. So as far as the exhibit P13 is concerned, by virtue of section 61 and section 62 of the Evidence Act, and due to the fact that the approver, the person who approved the document, was examined and cross-examined, and he in fact stated that while fixing the rates, approved government rates were utilized. And I just want to highlight the fact that the challenge as far as Exhibit P13 is concerned is only on the amount. They're not saying that it's a fabricated document. They're only saying that this amount could not have been arrived at this way. So that was their contention. Now, in that regard, I would like to give one small example, Your Lordship, one small example. So, for example, even in a court of law, Your Lordship, it is Your Lordship who dictates the orders. And it is the steno who writes the orders. But ultimately, before the order is issued, Your Lordship would put your signature on the order, thereby approving the contents. So it is not necessary that just because the steno has written down the order doesn't mean that it is her order.
Oh, that's a good example.
So similarly in this case, the draftsman may have written all those down, but it was under the direction of their superiors. Ultimately, it was the concerned authority that approved it. And second example that I would like to give is, Your Lordship, supposing that there's something wrong with Exhibit P13, supposing that the higher authorities are saying that you did not follow the rules or procedures or whatever, who will take the blame? Is it the person who signed it, or is it the draftsman who prepared it?
Yes, I got your point.
So that's why the fact that this court witness number 1, who affixed his signature and approved the Exhibit P13, was examined and cross-examined, would satisfy the conditions prescribed by the Supreme Court, which stated that exhibiting a document alone is not enough, the contents has to be proven. In fact, I've given that one judgment. I would not read it again, but that 2003 8 SCC 748.
Yes, 745 or 748?
745, I apologize. At paragraph 16. The only thing, the only requirement that the apex court has held is that evidence of those persons who can vouchsafe for the truth of the facts in issue. Evidence of those persons. It does not necessarily say that it has to be the author. Anyone who can vouchsafe for the facts of the contents of the document, that is enough. So accordingly, the person who approved it, that was examined and cross-examined. Now, assuming but not admitting that because he is not the author, his evidence cannot be accepted. By virtue of section 114 illustration F, it can still be presumed that it is the contents of the documents are facts, and the same can be accepted as it is by virtue of section 114 illustration F.
Yes.
Now, coming to my last point on this Exhibit P13, Your Lordship, as I have just stated that we have satisfactorily proven our case, thereby we have fulfilled the burden of proof. Now, as I stated yesterday, Your Lordship, burden of proof is distinct from onus of proof. On that, Your Lordship, that I would like to rely on this judgment. I will just read just one small para, 2006 5 SCC 558, para 19. There is, I apologize.
Yes.
Para 19.
Para 19, yes.
There is another aspect of the matter which should be borne in mind. A distinction exists between burden of proof and onus of proof. The right to begin follows onus probandi. It assumes importance in the early stage of a case. The question of onus of proof has greater force, where the question is, which partly is to begin. Burden of proof is used in three ways: to indicate the duty of bringing forward evidence in support of a proposition at the beginning or later, to make that of establishing a proposition as against all counter evidence, and to an indiscriminate use in which it may mean either or both of the others. The elementary rule in section 101 is inflexible. In terms of 102, the initial onus is always on the plaintiff, and if he discharges that onus and makes out a case which entitles him to a relief, the onus shifts to the defendant to prove those circumstances, if any, which would disentitle the plaintiff to the same. So, I have discharged my burden of proof. Now the onus is on the appellant defendant to prove otherwise. that would disentitle the plaintiff to the relief claim. In that respect, Your Lordship, I would like to take Your Lordship's attention to page 42, which is the written statement submitted by the defendant appellant.
Page 42 of the paper book.
Paper book. This is their written statement.
Yes.
Your Lordship may kindly turn to page 47, para 12. This is their submission regarding that exhibit P13. May I read, Your Lordship?
Yes.
Para 12, page 47. That with regard to the averment made in para 9 of the plaint, it is submitted that the assessment valuation of the Assam type house building of the plaintiff by the said engineer appears to be not based upon facts but on the information given by the plaintiff. The total valuation given by the officer concerned as 12,53,300 cannot be accepted in view of the fact that the Assam type building of the plaintiff was in dilapidated condition even before the said incident. Before dismantling of the said building, the defendant number 1 had frequently visited the said house and had even taken photos of the same. A glance over the said photos would clearly indicate that even as on the prevailing market rate, the house building will not have a value of more than 3 lakhs. They're saying that it cannot be more than 3 lakhs. In this connection, it may be further stated that the defendant number 1, with the help of an engineer, had thoroughly examined and evaluated the said Assam type house building of the plaintiff, and it was found that the total value of the said building as on the year of construction, that is 2004, had come to rupees 2,70,110, out of which depreciation of for 7 years, that is 92,140, if deducted, would come to 1,79,893. So according to them, my building value should be 1,79,000. They've come to this estimate based with the help of some engineer. And in that respect, they have also submitted one report of this so-called engineer. But in any event, I will not come to that. But this so-called engineer, number 1, was never produced by them as a witness.
Okay.
Number 2, the document which they have annexed in their written statement regarding that engineer report, they did not exhibit that. So a duty was cast. The onus had shifted to the defendant to prove otherwise.
Yes, I got your point.
So they did not produce this engineer as a witness. They did not exhibit the document which they relied upon.
According to their onus.
Yes.
According to the Supreme Court judgment.
Yes, Your Lordship. So that's why, under such circumstances, the trial court could not have come to any other conclusion other than to rely on the government document, that is the exhibit P13. And also, Your Lordship, if Your Lordship can kindly turn to page 85. This is the written argument.
Page
85. This is the written argument of the appellant defendant. And relevant page is at page 91.
Yes.
Relevant page is at page 91, para 7.
Yes.
Yes, out here, Your Lordship, I will not read the entire paragraph, just to show that defendant number 1, that is the plaintiff, had filed an application under Order 26, Rule 9, for setting up a commission for spot verification. They submitted an application under Order 26, Rule 9 for setting up a commission. And the conclusive part is at para 9 at the next page, Your Lordship.
Yes.
At para 9. The Honorable Court, via order dated 22/8/2013, disposed of the said application, stating that the court is of the considered opinion that verification or commission had been conducted through the District Magistrate Aizawl on 15/3/2011, the finding of which had been annexed to the plaint, and the court believes that as officials authorized by the government have conducted the commission spot verification. There is no further need to issue a fresh order for a commission spot verification. This is their application for spot verification, which was rejected. They did not file any appeal against this order. So by applying the principle of estoppel, they are now stopped from raising any objections against the reports prepared by the government. They did not file any appeal against this order of rejection.
Yes.
And lastly, on this exhibit P13, Your Lordship, just one last point. Your Lordship, may kindly bear with me. I'm concluding.
Yes, yes, of course.
Page 233. That is their grounds of appeal. Page 233. At ground number 5.
Yes, ground number 5.
Here, the appellant has stated that the building belonging to the plaintiff is, as per the initial report, is 30 feet into 21 feet, which comes to around 630 square feet. But whereas Exhibit P13 is saying that my entire area is 127 square meter, thereby there's a vast difference in the area so and so. That's what his submission was.
Yes.
What my learned friend has failed to explain to this honorable court is that this 30 into 21 feet is only the exterior length and breadth. It is not the carpet area of the house. And there are 3 floors. As such, there are 3 measurements. This is the floor space, Your Lordship. Versus this 13 to 21 feet is the length and breadth of the building exterior.
So this 30 into 21 feet is
Just the exterior outside,
not the carpet area.
not the carpet area. For example, if we take the length and breadth of this building, and there are like G plus 2 floors, obviously the carpet area will be much higher. That's why this is very, very misleading.
That is what impression I got.
Okay, I'm glad you're.
That is the impression I got, not the carpet.
I'm glad we're on the same page, then, Your Lordship. Now, coming to the second point of contention raised by my learned friend, he had stated that the damage of rupees 2,000 per month was not based on any evidence, so to say. But the apex court has held in various judgments that certain level of guesswork is allowed in such in calculating such things, so long as the same is not exorbitant. Now, the monthly rent which I use,
Inflation
yes, inflation.
can be calculated on.
Yes, it cannot be, there cannot be a straight jacket formula.
Yeah, that
Some
is-
guesswork has to be there. And if Your Lordship may kindly appreciate the fact that I filed my civil suit in 2011 July. Judgment came out in 2021, 10 years. So I used to collect in 2011 total rent of rupees 3,500 per month for the 3 floors. So an inflation of 2,000 rupees for 10 years period is not very exorbitant, Your Lordship. In fact, the demand for the urban housing in Aizawl has increased by almost like double in the past 10 years. So that's why the amount of 2,000 that was awarded is not exorbitant, and the same is acceptable in my humble opinion. And secondly, my learned friend has stated that I have only made a prayer on this and I did not make any pleadings. But if we go through my pleadings,
That is relating to your mental agony only.
I am on mental
Only
agony.
mental agony.
I am on mental agony, my lord. I'm on mental agony. So his submission was that I did not make any submission. I did not make any pleadings in my
Yes,
claim,
yes.
only in the
Except
prayer
the
portion.
prayer portion, yes.
But prayer is part and parcel of my pleadings. And also, if we go through the plaint, it can be ascertained that due to his illegal action for which they have not denied liability. Due to his illegal actions, I have been made to run from pillar to post. I have to go to the district collector, I have to run to this department, that department, to geology department, PWD. I have suffered. It is all due to his actions, which they have not denied. They are saying that, it's like saying that, yes, I killed this person, but I will not go to jail. Alright? How is that possible? And also, my learned friend has stated that no issues were framed on this. Mental agony, no issues were framed. That's why the court could not have considered it. But, Your Lordship, at issue number 6, the learned trial court has clearly framed this issue of whether the plaintiff is entitled to the reliefs claimed. If so, to what extent?
Yes.
That squarely covers my prayer. Because the relief claim can only be ascertained from my prayer portion.
All right.
And lastly, Your Lordship, on the amount of loss of income. My learned friend's main submission was that one of his witness, who used to be my tenant, had left in the month of March because of her own personal reasons and not because of the cracks, so on and so forth. But let's be clear on one thing.
That one CW1 lady.
Yes. Who was my tenant?
CW3?
DW3.
DW3, yeah.
She left because she got married and started living with her husband. In any event, the fact of the matter is that March 2011, that's when the DC issued the stay order. That's when the order for demolition of my house was issued, that same month. And also, their statement is that it is not necessary that tenants will continue to occupy that property for the last 10 years. We will never know that. Because of his actions, I was forced to dismantle. So, because of that, the benefit of the doubt has to be given to the plaintiff in as much as I could not get any more tenants because I did not have any house anymore. Because of his actions. Not of my own volition. Basically due to the fact that their grounds have no merit in as much as Exhibit P13, it was clearly exhibited, compared with the original. The person who approved it, the author, he was examined, cross-examined, thereby satisfying the conditions as laid down by the apex court. The original was produced, thereby making it a primary evidence as per section 62. And also the fact that after we discharged the burden of proof, the owners shifted on them to say otherwise that I am not entitled to relief claim. But they did not do that. They did not produce any, they did not exhibit the document which they relied upon. They did not produce the author of that document. So by applying the same principle, they have miserably failed to prove their owners. As such, the trial court could not have come to any other conclusion but the present conclusion. With that, I finish my submission, Your Lordship. Deeply obliged.
I'll give a short reply, Your Lordship. Your Lordship, regarding my learned friend's argument yesterday that Exhibit P13 was never challenged by the present appellant. In fact, Your Lordship, if I may take Your Lordship to the judgment at page 180, paper book page 180.
Page 180.
180 of the paper book. In fact, Your Lordship, we can, in fact, go to para 24 from page 174. Sorry, 179, para 24.
By the way, where is this person staying now? Does he have a house? Or
He has now constructed a new house, Your Lordship.
where?
In a different property, different land.
Property, different part. And what happened to this land where cracks had appeared?
Now, the appellant, as per the directions of the district magistrate, he
has
constructed the
something
retaining wall.
It's called the retaining wall.
Retaining wall, yes.
Yeah. So presently it's stable now. But
so this retaining wall, it keeps the land intact.
yes, it gives stability, Your Lordship.
Okay.
In fact, Your Lordship, regarding your query, page 207 of the paper book, I'll read para 83, just regarding your query, Your Lordship.
Okay.
If Your Lordship will kindly go to page 207.
No, I was wondering whether this person, he had already asked for a different plot of land in his prayer, different plot of land or something, some sort of compensation. That's why I was
Your Worship,
asking.
I mean, afterwards, I mean, nothing unfortunate happened. The land is still there.
Oh, the land is still intact now?
Yes.
Okay, the house has been dismantled, but the land is intact.
Yes, Your Worship, that is para 83 of the judgment, page 207.
Para 83 of the judgment, okay.
Page 207 of the paper book.
Yes, yes.
1, 2, 3. 10th line, para 83, 10th line. From the top 10th line, if I may read, Your Worship.
Yes.
Also, this court has personally visited the site and observed that the defendant number 1 has already constructed his building below the land of the plaintiff, thereby acting as reinforcement for the plaintiff's land. So, Your Worship, I mean, the land is intact. Now, if I may take Your Worship to page 179 of the paper book.
179.
Yeah, 179 and 180.
Yes.
Your Lordship will see para 24, the PW number 1 being plaintiff, so and so, he has exhibited the following documents.
Para 24?
Para 24, page 179.
Yes, yes, yes.
The PW number 1 being plaintiff, the case deposed by repeating everything same as explained, which was highlighted on para 227 of this judgment. And in addition to that, he exhibited the following documents. So next page at page 180.
Para 25.
No, para 24 only. The documents exhibited by the plaintiff.
Yes, these are the documents, yes.
Serial number 13. Exhibit P13 is a copy of building assessment number so and so dated 11/4/2011. Has Your Lordship got it?
Yeah.
And Your Lordship will see the sort of paragraph in between brackets.
Yes.
Photographs are objected. Has Your Lordship got that?
Yes.
Photographs are objected on the ground that the same are not accompanied by the negatives, and exhibit P13, that is building valuation, is also objected on the ground that the same is excessive and does not reflect correct value of the same.
So you have produced the photographs and
Yes.
everything.
No, Your Worship. No, I'm saying that my learned friend had said that exhibit P13 was not objected when it was exhibited. But the judgment clearly shows that it was objected to by the defendant. Number 1, writ appellant. Yesterday, my learned friend had stated that exhibit P13 at the time of exhibition by the plaintiff was not challenged. But this part of the judgment clearly shows that the exhibit P13 was not accepted by the defendant number 1. He had challenged it when it was exhibited.
Yes.
And my learned friend had said that onus of proof and burden of proof is
Yes,
different. But as my learned friend had already read from the Supreme Court judgment, initially onus of proof is on the plaintiff, who relies on that particular document to prove its contents.
This is the basic theory of civil
Yes.
law.
They could
Then
not.
it goes to the defendant. Basic theory of
Basic
civil,
theory.
civil
They could
code.
not prove its contents. My learned friend had said that the court witness number 1 had vouched for it, for its authenticity. But the only person who could vouch for the authenticity of the exhibit P13 is the draftsman who had made the assessment. They did not even mention the name of the draftsman. He was not produced as a witness. So I think there's a little misconception on my part of my learned friend that the only person who could vouch for it is the draftsman who prepared the assessment, not the person who signed it. And because the person who signed it in his cross-examination has admitted that he did not make the assessment. So what does his signature amount to? When he is admitted that he was not the person who made the assessment, he did not even visit the building. And regarding Your Worship, my learned friend had said that 630 square feet is the
I think it will be perimeter.
perimeter and not the carpet area. But no evidence was led in this regard. by them? Where is the evidence to prove that this 630 square feet was only the perimeter area and not the carpet area? There's no pleading to that effect in the plaint. There's no evidence led by them. It is their own document, Exhibit P10. There's no evidence led by them to prove that this 630 square feet is only the perimeter of the Assam type building. It is not the carpet area. It is not even in the
630 square feet, meter or feet.
630 square feet. It's in Exhibit P10. I'll take your lordship to Exhibit P10, which is at page 23. It starts from page 23.
Yes, yes. We have gone through Exhibit
Yes.
10.
It starts from page 23.
Yes, we have gone through this.
In fact, Your Lordship, if I may read para 1 again, the crack caused, page 23.
Yes.
The crack caused by the house site development, preparation of Sea Lal Tanpuya, has made the Assam type building belonging to P. C. Lal in Oma, which measures 30 feet into 21 feet and is also occupied by 3 families unfit for occupation. So nowhere has it mentioned that this is the area of the perimeter. And in their pleadings also, they have not mentioned that this is only the perimeter area. Even there's no evidence adduced by them to show that this is the perimeter area. So, and this is their own document which has been exhibited by them.
Okay.
And Your Lordship, again, my learned friend had said that some guesswork has to be involved in
Yes, yes,
calculation.
there is a judgment also.
Yes, there's, but Your Lordship,
Relating to inflation prices. And
yes. But then there's no,
Relating to the condition, present
Yes,
situation and condition. There is a judgment I have come across, but
but
I've
Your Lordship,
forgotten.
again, no pleading, no evidence, nothing of that sort. How could the court have gone on presumption or assumption that inflation is this much?
Yeah.
There's no evidence there's no evidence led by them.
He has stated that, you see, prayer is a part and parcel of pleadings. That is what he has stated.
Okay, Your Lordship, if we admit that prayer is part of the pleading, then where's the evidence to prove the pleading? There's no evidence adduced by them. We cannot just go on the pleadings. The pleadings have to be proved by way of evidence. Where's the evidence adduced by them? Since if we are admitting that the prayer is a part of the pleading, then where's the evidence to prove the pleading?
Just one more point.
Yes.
It has emerged that he went from door to door. It has surfaced to the evidence that he went from door to door to the DC, to the geologist. Then his house had to be dismantled. So won't it amount to mental agony?
Your Worship, now he's saying that he went to door, but in the plaint,
There is nothing.
he just submitted a complaint.
Yeah.
On the basis of the complaint, the DC took action. He detailed, gave an order detailing spot verification. So everything was done by the DC. I mean, he did not have to run from pillar to post to the PWD, to the geology
Yes,
department.
yes.
There's nothing on evidence. The only thing he did is he submitted a complaint to the DC, and DC took the required action. So, I mean, this plea now that he had to run from pillar to post, it's not in the pleadings, it's not even in the evidence. The only evidence is that he submitted a complaint to the DC. The rest, the DC took care of. So, I mean,
Yes.
the evidence, even the pleading, does not support his claim that he had to run from pillar to post. So, Your Worship, that is the main thing, is that the exhibit P13 could not have been relied upon. The mental agony also, Your Worship, okay, there may be a prayer made, like we said yesterday, but there is no evidence regarding that. So that is why, Your Worship, my humble submission is that it is too exorbitant, the quantum of damages. And it cannot be, there's no
They have
evidence.
already withdrawn
4,50,000.
50,000. There you have no objection.
Yeah. I leave it to your Lordship.
So I'll come back on Monday then.
Yes, Your Lordship.
You have anything to ask? Anything
Just
to
one,
say?
just one clarification on that mental agony. My learned friend has stated that there is no specific pleading, but Your Lordship will know very well that even in an application for, let's say, rejection of plain under Order 711 for lack of cause of action, just because a person has failed to state in his plain that the cause of action arose on so and so, so and so, just because those specific words are not there, it should not be rejected. It basically says that if you go through the plain and if you can ascertain that there is certain cause of action arising, then it should not be rejected. The same principle can be applied here. It can be ascertained from the plain that I was made to run from door to door. But why? Why was I made to run from door to door? His fault, his liability, which he has not denied.
Okay. I'll come back on Monday. Maybe I'll pass an order on that day itself. I may ask a few questions or
Madam.
I'll pass the order.
Yes, Your Lordship.
Thank you, Lord.
We're deeply obliged.
You will be present on Monday, no? Both of you.
Yes, Your Lordship.
Part-heard Learned Counsel Mr. A.R. Malhotra and Learned Counsel Mr. Jordan.
No, Lal Fakoma.
Huh?
Lal Fakoma.
Lal Fakoma
Yes, Your Lordship.
for the appellant and the respondent.
Number one.
Respondent number 1. State Learned Counsel Miss Government Advocate for the state.
Miss Mali is there
Yes,
online.
Huh?
Lordship, I'm appearing for the state.
Oh, yes,
H.
yes.
Ramal Swami
Yes.
ji.
Learned Counsel Miss.
H. Ramal Swami. I think it's in my screen.
Okay. লিখি দিবা হা নামটো এনে আন্দাজৰ মনজৰ লিখি পেলাই পাছত সুধি লবা list the matter on Monday. Monday is what? 11th.
I'm open.
Yes.
Deeply obliged.
Oblige.
Yes, along with the like yesterday, that will suffice. Yes, we can. Then 11:45, I'll take a break. I think somebody is there present for principal seat also. Then we can keep it pending for a time being also if nobody appears.
Principal seat matters. For motion, item number 1 and 2.
This has not been connected, then we will take up they are present for principal seat. We can take that up. Oh, it has been connected. Okay.
May I see the lordship?
Yes, 1 and 2.